Hello everybody, welcome to iExamB's Legal Bee. This is Amrita, your law faculty here at iExamB. I have started a new series on iExamB's Legal Bee channel that is relating to important judgments from different subjects for Central Bureau of Investigation, that is CBI APP examination. इस एग्ज़ाम के लिए केस लॉज को पढ़ना काफ़ी ज़्यादा इम्पोर्टेंट है, इसलिए मैंने एक सीरीज स्टार्ट की है एंड इसमें मैं टॉपिक वाइज जजमेंट्स कवर करने वाली हूँ. 5 important judgments is the name of my series. I have started this series with a video which is first from IPC itself, 5 important judgments from the general liability, general exceptions. And in this video today I'm going to cover 5 important judgments from criminal liability. Criminal liability भी एक काफ़ी important सब्सटैंशियल टॉपिक है आईपीसी में से. उसमें काफ़ी सारे कंसेप्ट कवर्ड हैं एंड इसमें से काफ़ी सारे इंपॉर्टेंट जजमेंट्स भी हम लोग इस वीडियो में डिस्कस करने वाले हैं. So once again, welcome to iExamB. If you have not subscribed our channel yet, I would suggest all of you to subscribe. If you have any queries, you can reach out to us on hello@iexamb.com, call us on 920-5524028 or visit our website www.iexamb.com. So the first case is Alauddin Main versus State of Bihar case. In this case, the importance of section 149 of IPC has been discussed. The Honorable Supreme Court of India has observed that this section creates constructive liabilities and makes every member of the unlawful assembly liable for the offense or offences that are committed as a result or in the course of occurrence, provided that the same was or were committed in prosecution of common object or was or were such as the members of that assembly knew would be likely to be committed. So this case is basically elaborating on the point of view of common object, common intentions. ये काफ़ी important topics है IPC में से एंड इसमें से डिफरेंस भी बहुत बार पूछा जाता है एग्जामिनेशन में. सो इससे रिलेटेड केस लॉस तो हमें डेफिनेटली पढ़नी ही चाहिए एंड बाय वे ऑफ स्टडिंग दीज केसेस आवर कंसेप्चुअल क्लैरिटी इंक्रीजेस इवन फर्दर. So this case, Honorable Supreme Court has clearly defined that Section 149 is creating a constructive liability. It is connecting the members of the unlawful assembly basically with the offense committed. And how it is committed, it is in the course of occurrence of which activities and what was the objective for that which was common, and connecting all the individuals is discussed in this particular case. Ramapasi and another versus State of UP. This is another case which is dealing with common object section 149 of IPC. It prescribes for vicarious or constructive criminal liability for all members of an unlawful assembly. So this is talking about the vicarious liability element of section 149 of IPC. यानी कि जो कंस्ट्रक्टिव क्रिमिनल लाइबिलिटी की हम बात कर रहे हैं, जिसे हम वाइकेरियस लाइबिलिटी भी कह सकते हैं. ये कंसेप्ट आपने टॉर्ट लॉ में भी पढ़ा होगा. That is vicarious liability, one person is made liable for the acts of another, like master is liable for the acts of his servant. So this is for all the members of an unlawful assembly where an offense is committed by any member of such an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be connected in the prosecution of that object. So this is what Honorable Supreme Court has mentioned in this particular common object or section 149, that the connection is such again that the members of the unlawful assembly will be connected and the liability will be vicarious or constructive criminal liability, and the members of the assembly, that is the unlawful assembly, they knew it or they had the knowledge that it is likely to be connected or committed, means whatever the activity they are intending is likely to be committed in the prosecution of that object. Another important landmark case is Sanju versus State of Madhya Pradesh. In this case, the Honorable Supreme Court of India has talked about the concept of abatement, that what actually abatement means. So abet means to aid, to assist, or to give aid to command, to procure, to counsel, to countenance, to encourage, or to set another person to commit, another one to commit. यानी कि abetment is facilitating the commitment or sorry, the commission of an offense. So Honorable Supreme Court has covered all these words or phrases to define the scope of abetment in this particular case. This is also a very landmark case. Generally, a person who has committed it is liable for it, but principle of abetment emphasizes that one who helped a criminal or provided him assistance can also be held liable. So, assisting or facilitating the process of crime by aiding the person, for example, or encouraging him, instigating him, all these things are also constituting an independent offense of abetment. Next case, Kopula Venkat Rao versus State of Andhra Pradesh. In this case, the Supreme Court has observed about the word attempt, that the word attempt is not itself defined in IPC. So if we take the ordinary meaning of that, an attempt to commit an offense is an act or a series of acts which led inevitably to the commission of the offense, unless something which the doer of the act neither foresaw nor intended happens to prevent this. Means, by the ordinary meaning, what is the meaning of attempt? An attempt to commit an offense is an act or a series of acts which led inevitably to the commission of the offense. So whatever acts have actually formed a chain in the commission of the offense, those are going to be the facts constituting an attempt. An attempt can be described to be an act done in part execution of a criminal design, like a criminal design is already prepared and you are executing it in part. It is not completed yet, but you attempted that. That is something which is not successful crime, but it is an offense independently because you attempted. For example, attempt to murder. This amounts to more than mere preparation, but falling short of actually consummation and possessing, except for failure to consummate, all elements of a substantive crime. So this is also an important thing that is discussed in this case, that attempt is something more than mere preparation. You know what are the different stages of crime, and that you have to know for this particular case laws will help you with that. What are the stages of crime? Preparation के बाद कौन सी स्टेज आती है? And when we talk about attempt, then attempt is something more than mere preparation. Lastly, Pandurang versus State of Hyderabad 1955. In this case, the court has held that the person cannot be held vicariously accountable for the actions of another if their purpose to commit the crime was not common. Now this is also a very important judgment, I would say, over here, because here what the court has observed is relating to section 34 of IPC, that is common intention. Now when you are imposing liability on them, you are imputing vicarious liability on them, you are making them accountable because of vicarious liability, then you have to connect them to the offense. But if it is proved that their intention was not common for committing their crime, if it is not a common intention, their conduct is independent of their acts, then it is not for the same purpose. If it is supposed connected, then only we can say that section 34 is applicable, and if 34 is applicable, then only we can apply the vicarious liability concept. So this was all about the important concepts covered by way of important judgments from the topic of criminal liability from IPC. So such kind of videos we will be coming up exclusively at Legal B, topic wise cases for CBI APP Law exam preparation. If you have any queries, you can reach out to us, and also don't forget to subscribe to Legal B. Thank you everybody.